A general approach is that law enforcement agencies do not disclose the names of individuals who have been or are being investigated. This general principle is subject to exceptions. One example where names have been disclosed is where the offender has absconded or left the jurisdiction while investigations are ongoing. For example, members may recall the case relating to P. Jiaping and Pansuk Srivipa. The couple was involved in a series of alleged cheating cases involving luxury goods. They fled Singapore last year in 2022 while investigations were ongoing. The police released their details. A second example would be where the facts which constitute the alleged offenses and the individuals who may have committed the alleged offenses are already publicly known. For example, as a result of findings made by our courts, and there is some public interest in disclosing that investigations are underway. Such disclosure has to be weighed against possible prejudice to the individuals concerned. There are a wide variety of situations where it may become necessary to make public the fact that a person is under investigation or has been arrested or is assisting in investigations. We have to assess the facts and the public interest involved. The circumstances relating to Mr. Lee Hsien Yang and Mrs. Lee Swet Fun straddle the first two examples that I mentioned. The discussions surrounding number 38 Oxley Road are of significant public interest. One might say they are of at least as much interest as in the case of Party Liani, if the two can even be compared. The Oxley Road matter was debated extensively in this House following ministerial statements on the subject. The findings by the disciplinary tribunal and the court of 3 judges in the disciplinary proceedings against Mrs. Lee Swet Fun and their findings on Mr. Lee Hsien Yang and Mrs. Lee Swet Fun are matters of public record. Both the disciplinary tribunal and the court of 3 judges found that Mr. Lee Hsien Yang and Mrs. Lee Swet Fun had lied under oath. The case of Keppel Offshore Marine Limited is quite different. It does not fall within the different examples I've set out. Members may not know this, but it was KOM which had made the CPIB report. The CPIB had conducted as thorough an investigation as it could with the information and powers that it possessed. It turned all the stones it could and assessed the evidence together with AGC. They concluded that they could not sustain any charges in court.